appeals the trial court's denial of his motion to dismiss 2 counts, threatening to discharge a destructive device and his attempt to do so. He filed a C4 motion in which he alleged 9 paragraphs that outlined the undisputed facts in this case. The state did not file a traverse and therefore admitted and conceded to all of the facts as stated in the motion to dismiss. Essentially, Mr. Cano was a 17-year-old student. He told his friend, who the state is calling a CI, but it's very important to distinguish, he was not an agent of the state when these statements were made to him. When Mr. Cano spoke to what is called the CI in the record, he was his best friend, his closest friend, whom he thought he was going to be joining in planning these, what we'll call half-baked scheme, and I'll get into that into the attempt portion. But as far as the threat, count 1. The statute requires that somebody threaten to discharge a destructive device. The statute does not define what a threat is. Under the rules of statutory construction, the courts are required to look at the plain meaning. The plain meaning, as defined by Black's Law Dictionary, indicates a communication of that threat. In fact, Black's dictionary defines it as a communicated threat to inflict harm or loss on another, or an indication of approaching menace. Our position from the forefront was this person to whom he made the statements could not have possibly been threatened because he was essentially a co-conspirator.
Do I understand your argument to be that the threat has to be made to the individual or individuals to whom the harm is expected to come? For example, if it was at the school, to the school or to the people at the school, otherwise it's not a threat.
I think that that's the most conservative reading under the First Amendment, that it has to be to the intended victim. However, our position doesn't need to get that far because our position isn't whether or not the confidential informant was the intended victim. It's that the confidential informant was actually his co-conspirator. In denying this claim, the trial court found a Massachusetts case that dealt with a totally unrelated statute and said that that case specifically said it does not need to be to the intended victim, that it just needs to be communicated. And interestingly, it's our position that that case bolsters our argument because throughout that case, the Massachusetts court discusses the fact that the statements to the co-conspirator could not be the threats. And what's important is to distinguish what these statements actually are. So Mr. Cano has these conversations with his friends. He tells him about his interest in Columbine and Virginia Tech. He discusses using a pipe bomb, but with no real explanation as to how he's going to make it. This confidential informant made clear he never saw any of the journals or videos that the state later found in Mr. Cano's room.
Ms. Martinez, this is what's alleged, that he wanted to commit suicide, correct? And that he wanted people to feel the same pain that he did, and mentioned Columbine, correct? Actually mentioned not only Columbine, but Virginia Tech and Oklahoma City, correct? And then also that he wanted to use a propane pipe bomb to inflict pain on people. And that he also wanted to kill 2 assistant principals. And he mentioned them by name with a machete.
Importantly, Your Honor, the statements about the machete are totally inapplicable to what he's charged with. He was not charged with attempted murder, threatening to murder. He was charged with threatening to discharge a destructive device. So throughout the record, there is a lot of inflammatory references to the machete, to guns. None of that is relevant to the trial court or this court's analysis as to whether or not he was actually guilty or there was sufficient evidence of the fact that he threatened to discharge a destructive device. Now, we don't argue the fact that the statements fall under what the statute is requiring, meaning it was talking about bombs. He talks about a pipe bomb that qualifies as a destructive device, and we don't argue the fact that it was intended to do harm, as the statute requires. What our position is this appears to be an issue of first impression in the state. This court has reviewed this statute in other situations. In the Reed case, it was a bank robbery, where the defendant goes in.
Let me take you back, because you keep saying that this was all general. Didn't they also find a journal, a very detailed journal, that he's specific, it was a detailed, specific plans how to bomb the Freedom High School?
Yes and no, Your Honor. Yes, there was a journal. It had some very rudimentary, immature stick figures in it. However, the record is clear. This confidential informant never saw that journal.
Well,
So-
well, let's proceed. But this is when the police finally arrived, and they also found, what is it, a plastic tub that contained, we don't know what kind of substance, that appeared to be bomb-making materials.
I disagree with that conclusion about what the materials were. There was an independent forensic evaluation. The state did not argue with the results of that. Those materials, what the state is calling possible bomb-making materials, is Morton salt substitute, some ground-up pencil lead, sugar, some fertilizer. So,
And the main reason I was very clear in reading that, because this is verbatim from your motion that you set forth,
yes, ma'am.
okay?
It's our position that nothing that was found in his room is relevant to the threat. And I will address how it may be relevant to the attempt conviction, but as far as the threat, the state conceded at the hearing on the motion to dismiss that the threat needs to be communicated, meaning somebody has to hear it. You can't just say it in a vacuum. So the journal, the video, none of that is relevant to the threat. So from our position, it has to be the statements that he made to the confidential informant. When he's talking to the confidential informant saying, I want to use a pipe bomb to inflict pain, here's a map of Freedom High School, it's our position he is discussing this with someone who he thinks is going to take the action with him. So by definition, he cannot be an intended victim.
He doesn't,
Statute.
but does he have to be the intended victim? That's the point I'm trying to get back to. You cite to a case to stand for your proposition, but I don't read the case that way. The case doesn't say it has to be the intended victim. It just says a threat is made.
In reaching this decision in this case, the court does not have to go that far. Although we do, our position is that the communication should be to the intended victim. The court does not have to go that far in this case. What we're asking the court to find is that it cannot be to a co-conspirator. It's important to
Do
understand
you have a case that I can rely on that?
the Massachusetts case. That
In Florida, do you have a case?
No, sir. There's no Florida
Is
case.
there any state closer than Massachusetts that I can come?
There's not. There's federal case that talks about different types of statutes, like when a threat is mailed, that it does have to be the intended recipient.
That's a different statute.
Exactly. And so that's a little bit different factual scenario. There is nothing on point. That's why this is an issue of first impression. Our position is that the point of the statute is not to punish planning. The point of the statute is not to punish thinking about bombing. It's to punish the terror that is created when the threat is made. Because that's what essentially this is. This is an anti-terrorism statute for all intents and purposes, because you're talking about the threat of doing something. And so our position is the CI was in one of two positions. Either one, he was planning on doing this with Mr. Cano, as is even evidenced in the controlled call. Mr. Cano gets on the phone with this guy and says, hey, I thought you wanted to be a part of my plan. What's up? The CI says, no, I just want to die. I don't want to be part of your plan. Or he had an option to not be there. So he was not the recipient of the terror that the statute is trying to protect. To hold otherwise, to use the state's finding that it has to be to the intended victim, or that to anybody, just a statement as long as it's made to somebody, raises some really serious First Amendment concerns. Because at what point then are you punishing just speech and not the result of speech? Because the whole point of the line of cases that say that you can punish speech is when it has some sort of incendiary result, when it's to incite some sort of chaos or disruption. And so it's our position that a statement made to somebody with whom you're planning on doing this act cannot be punished under the statute.
This case comes to us in the posture of a C4 motion, is that correct?
Yes, sir.
There's not a challenge on a facial challenge or an as-applied challenge down below, is that correct?
Correct. And as a result, the review is de novo, and this court is required to apply the law from scratch. Our position is that the statements to the co-defendant, to the confidential informant, were he wanted to inflict pain, he wanted to use a pipe bomb to do so, and he pulled up a map of Freedom High School. It's our position that cannot those actions to the confidential informant, who at that point was not an agent of the state but his best friend, cannot qualify as the threats. To address Judge Cosum's concerns about the journals, I understand that those are relevant for the attempt. He was also charged in count 2 with attempting to make a destructive device. The statute reads in the alternative making or attempting to. At the hearing, it became clear the state was pursuing only a theory of attempting to do so. In denying the motion to dismiss, the trial court found Mr. Cano had obtained a recipe, he had began collecting materials, and he had perfected a timer. So he had gone enough into an attempt. As this court knows, in every attempt you need a plan and an overt act and a furtherance of it. So we can see he clearly had a plan, however rudimentary. He had a journal with his stick figures as to it listed out times, it had some pictures of the school, and he did get a recipe. However, what's very important is to focus on what materials were actually found in his room. They were absolutely undisputed household materials. By no means had he gone and met with somebody to get some sort of explosive material, gotten any sort of illicit material. The forensic report makes clear these are non-combustible items. None of these items, if combined, could have made a destructive device. We're talking about salt, sugar, fertilizer, match heads, and pencil lead. What is called charcoal in the police reports is actually ground up pencil lead. What the forensic report notes is these combination of materials are obviously done by somebody who has no knowledge of explosive devices, because actually some of the materials were inert, which would mean that they would make it non-combustible.
But isn't the issue that he was still trying to make a bomb? Isn't the issue the attempt that he was trying to make it?
Your Honor, yes, but the law requires that he go beyond mere preparation. In this case, there was some plastic tubing. However, no materials were found that were going to allow him to encase this tubing. There was nothing to cut the tubes, there was nothing to seal the tubes, so you have some ground up pencil lead and some salt and some tubes. Under no plausible scenario, according to the forensic report, would that ever create a destructive device. So yes, he got in the recipe. Yes, he may have really wanted to do it, but the law doesn't punish us wanting to do things. The law punishes our actions in trying to do something.
But weren't his actions in trying to do it, whether or not he had gotten the right formula yet, the right materials? Isn't the issue that he was attempting to do it?
Your Honor, the case law that interprets attempt says that there would have been enough to complete the act. That there would have been something there for the act to be completed, but for some sort of intervention. And in this case, that's totally not possible. And no, he would not have been able to construct that device. With interest.
So is your position that he would have had to have been able to construct it?
No,
he would
sir,
have had to have it done before it reaches that.
He would have had to at least start combining materials in a way that would have led to that, which he did not do.
I see what you're saying.
And the materials in there were by no means explosive or otherwise destructive. The state wants to argue that we don't know how far along he had gotten. Yes, we do. We know he had mixed together a bunch of powders that meant nothing, that had no sort of ability to make any sort of explosion. The state also says at the hearing, we don't know how far along he would have progressed. Well, that's the whole point. He's hurt, we don't know. We don't know how much more he needed to get to what would have been a completed destructive device. There also seems to be great issue below as to this idea that he had perfected what is called a time-making device. And I think it's very important to be clear about what that means. We're talking about a digital alarm clock, a household digital alarm clock that had the red and black wires split out of the back. This is the so-called device that he had perfected. In the forensic report, it details the fact that this is not a very effective timing device because of the fact it has to be plugged in. So the presumption is he would go to the high school, have to find an outlet, and plug it in before it would actually work. So I certainly take issue with the characterization. All that fact is undisputed that he had been working on a timer. I take issue with the characterization of it as a timing device because of the fact that there's no evidence to show that it was actually capable of functioning to detonate anything.
Let me ask you one more question. On your motion to dismiss, you're talking about the things that were found there. In your motion to dismiss, though, it appears that there were a lot of things recovered, whether or not they were put together to make a bomb. It's another situation. I mean, we've got, I can't even go on. We'd be here forever. Rolls of aluminum foil, a light bulb wrapped in duct tape, exposed filaments, 3 pieces of PVC pipe, aluminum foil, 10 pieces of aluminum pipe, a bowl of matchsticks, nuts, bolts. I mean, I'm just having a problem with the argument that he has to be able to make the bomb, when to me this just shows that he attempted to do so. And on overt act, he's trying to get everything together.
Well, Brennan, these things weren't all neatly together in a box. These things were scattered on the front porch. These things were scattered in various Tupperwares.
Why is that?
Because they're household items. They're common household items. So things like the nuts and the bolts or a broken light bulb, I don't think we can draw the conclusion that they were intended to be a destructive device. I understand the conclusion that these unknown powders may have been so.
How about the .38 caliber shell casing? How about the PVC pipe? How about, I mean, I guess I share with Judge Suarez is that they find all of this stuff, and I don't think the law requires that he has to be capable or he has to make sure that it's all ready to be used. I don't think there's that requirement.
I agree it doesn't have to be completed, Your Honor, but it has to be showing some sort of evidence of being on its way to completion, that it will be completed. We have a child's harebrained scheme. And
okay, well, let me ask you this. How about a scenario where everything is done except the timer? They can't do it?
I would concede that he is much closer to the attempt at that point. However, this.
Okay, so what if then, let's go a little bit further, what if everything is done, well, it just needed to have like 2 more steps?
At that point, at least something has been combined. If something had been, if the pipe had been sealed, or if the materials together had been combustible, any of those, I would concede he would be much more on his way to an attempt. In this case, he has a recipe. It doesn't appear that he had actually obtained any of the materials on the recipe. That these powders are not in any way formable to make some sort of explosion or some sort of destructive device. And they have these scary names: calcium carbonate, potassium chloride. But what the report actually says is these are household items. This is fertilizer. This is salt. This is sugar.
Well, you could actually do a bomb with just use a fertilizer. It could be done with a lot of household items. You could actually put together an explosive material.
With pounds
I think
and
that's what Mr. McVeigh used.
Mr. McVeigh? Okay.
pounds and pounds. In Oklahoma City, a U-Haul truck full of fertilizer.
Way past the 15 minutes. I will at least say you 4 of them.
Thank you.
Thank you very much.
Thank you.
Good morning. May it please the court. I'm Suzanne Bouchard, and I represent the state in this case. And again, the court's review here is de novo. This was a C4 motion, and our contention is that the trial court properly denied it. In order to survive a C4 motion, the state has to show that it can make a prima facie case. There's no need for the state to show that it can present the sufficiency of the evidence to sustain a conviction. That's not the purpose of the review of a C4 motion. So to the extent in count 2, and I'll get to that in a minute, but to the extent in count 2 that we're arguing about sufficiency of the evidence and disputes about whether or not this defense expert knew what he was talking about or whatever, we never got to that point. This was a C4 motion to dismiss for failure to state a claim. I'd like to address count 1, the threat. There is no indication in this record whatsoever that the CI was a co-conspirator, that the CI was ever a co-conspirator or a co-defendant or anything like that. This apparently was a friend of Mr. Cano's, and the two of them had talked, I guess, about suicide and whatnot. But when it got to the point where Mr. Cano was talking about wanting to blow up the school, that's when this individual became a CI. That's when he left the apartment. Next day he told his mom, and they contacted the police, and that's what gave rise to this controlled phone call in which some of this stuff about Columbine was discussed. Now, with regard to interpreting this statute, this is section 790.162, and it says, it is unlawful for any person to threaten to throw, project, place, or discharge any destructive device with intent to do bodily harm to any person or with intent to do damage to property of any person. There's nothing in that statute that indicates to whom that threat must be made.
Would you agree that it must be communicated to some person?
It must be communicated to some person, obviously, otherwise it's not a threat. But the legislature...
Or go back to that conundrum when tree falls in the forest, there's no one there.
Exactly. And we don't really want to go there today. But in my brief, I compared this statute to section 836.10, and that's the statute that forbids threatening someone by letter or email or other sort of communication device, threatening an individual to do harm to the individual. And that statute clearly specifies within the plain language of the statute that the threat has to be made or received by the intended victim or a member of that person's family. The legislature knew how to include that kind of language in a statute. It did not do so in this case. So it's the state's position that the trial court got it right on this one, that the defendant did in fact communicate a threat to this person who became a CI and stated that he wanted to make a propane pipe bomb to blow up the school cafeteria. He wanted to inflict a lot of damage, a lot of casualties, and he wanted to be a legend, and more death and destruction, I guess, than Columbine or Virginia Tech. So it's the state's position that the plain language of this statute does not require that it be communicated to any particular person, or that the threat be communicated to the intended targets, or even that the person who receives the threat is in any kind of emotional state about it, such as fear. With regard to count 2, the attempt to make a destructive device, counsel is correct. It was the state's theory that he attempted to make, and the statute provides that the attempt to make a destructive device is contrary to this provision. So the legislature wanted not only to prevent the making of an explosive device, we're talking about bombs here. They want to keep people from even trying to make them. So when you start collecting all these materials, then that's the attempt to make the bomb. And I know that there's been a concession that the intent, and we're talking about the elements of intent. So, you've got to have the specific intent to commit the crime. So there's been a concession that, we really don't have an argument about that. What the sticking point is the overt act, beyond mere preparation, done towards the commission of the crime. And in this instance, it's the state's position that we didn't have to show at this point, because we were charging attempt, we didn't have to show that the timing device worked. We didn't have to show that the bomb was made. When you start collecting these materials, that's pretty dangerous in and of itself. And we've got things like, if you look at the DOJ lab report, I believe that was attachment 3 to the motion to dismiss, and it's on page 147 of the record. You've got various mixtures of chemicals, including things like combinations of calcium carbonate, potassium chloride, ammonium nitrate, calcium magnesium carbonate, potassium chloride, and sodium chloride. So you've got various chemicals that have been collected, along with sections of PVC piping, sections of metal piping. It's pretty clear what was going on in this case. The defendant in this case was attempting to make a bomb. He wanted to carry out his goal of going in on April 20th into the school cafeteria, setting various pipe bombs in place, and having them timed out so that they would go off at, I believe it was 7:12 or something like that. So,
did one of the reports suggest there were like bolts and?
There were apparently bolts, I guess, and screws or something like
Which
that.
is what arguably, when assembled, you place inside the pipe. The
Possibly
explosive
for
device.
shrapnel. Yes. So,
Common nails would work too, I suspect.
correct, Your Honor. So it's the state's position that clearly, again, the issue in this case is, could the state make a prima facie case? And under the admitted facts in this case, yes, the state can make a prima facie case that the defendant attempted to make a destructive device. So we would ask this court to affirm the ruling below. Thank you.
Thank you.
You still have 4.
Thank you. Related to the threat count, what's important to understand in the rules of test case construction is that when you have an ambiguous term, and in this case, our position is that the term threaten is ambiguous because the state and I have different interpretations of it. So
How is it ambiguous?
because it doesn't define, it doesn't.
Does the statute have to define it?
It doesn't. But so then we go to the common meaning, and as we discussed in their Black's dictionary, that has to be communicated, and then the state is conceding that. So then the question becomes communicated to whom? And
Well, Black's Dictionary says a communicated intent to inflict physical or other harm on any person or any property. It doesn't say it has to be to any individual. It doesn't say it has to be to the person that you're going to harm. It just says you communicate a threat.
And I understand, and that is a reasonable interpretation, Your Honor, but for the rule of lenity, which says that statute has to be construed in favor of defendant when there is some sort of ambiguity. And so our position is that to read it, to allow statements to the confidential informant.
Well, I didn't mean to interrupt you, but I go back to my question. An ambiguity is two reasonable, different interpretations. I don't see an ambiguity with the word threat. You may have a problem with who does the threat have to be made to. That's a different situation. That's not an ambiguity in my mind. Threat is defined. Your argument is that it's got to be made to an individual to whom it's going to be made. The threat is the harm is going to be made, and that's not what the definition says.
And I agree, it does not say that, Your Honor. Our position is that a reasonable interpretation under the rule of lenity is that it cannot be made to someone with whom you are planning to do the actions that you are threatening to do.
I see what you're saying.
As far as the...
So any other third person would suffice? So for example, if one of those boys' parents would have walked in the room at that time and were saying, I'm going to blow up the school, that person would be an okay recipient of that message to constitute the crime?
Reluctantly, I would have to concede, yes, that person could perhaps feel the terror that the statute is trying to prevent.
Arguably, the statute's trying to prevent the making of a threat with an intent to do so, to do the harm.
Yes, Your Honor, but our position is how can it be a threat? How can it be threatening to someone who's going to be doing it with you, or at least you perceive is going to be doing it with you? And there's no question that that's what he thought.
Does the threat have to actually impose a fear on the recipient or communicate the knowledge of the threat to the recipient? The statute's language says it's unlawful to threaten, which seems to make the communication that is that of a threat. In this case, the friend of the CI, whatever co-conspirator, would have understood a threat was being made, which arguably meets the plain language of the statute.
I would concede that a third party could be a victim of the statute. Our position is that because this person, this other high school student, was someone who he thought was going to be taking the action with him, he could not be threatened under the statute. It would not make sense otherwise. It would not make sense for somebody, if the point is to protect the fear that it imposes, this idea of a destructive device, if somebody who's doing it with you, or you believe is doing it with you, they're not going to have that same fear.
Don't you have a problem with that argument if he's a co-conspirator, if he's a co-conspirator? Then, to follow up on the judge's question to a third party, your co-conspirator told his mother about the problem and the threat that was being made, so does that accomplish?
At that point, the confidential informant is the one who's making the threat, is our position.
No, he's one of the co-conspirators, so he's telling his mother and telling her what the threat is of what they're going to do.
I understand that the court's argument with that. I don't believe the state ever had any theory other than that the victim in this case, the victim of the threat, was the
I'm just
confidential
following up
informant.
on your argument that this is a co-conspirator, and my thought is, just off the top of my head, and I could be dead wrong, I've been known to be, that it just seems like it's counterintuitive to your argument because he made communication to his mother, therefore it's to a third individual. But it doesn't really enter into your argument. I'm just
And I understand the court's position. I think that if Mr. Cano had made it to the confidential informant's mother himself, then that could have been punishable under the statute. Do I have time to address the text?
I'll give you 30 seconds to sum up, since we've taken a little bit of your last vestiges of time from you.
Thank you, Your Honor. As far as the attempt statute goes, this court had an opportunity to consider a similar situation as far as what it takes to get to something. It's totally unrelated statute. It's kidnapping, but it's the Enix case in 2011. In that case, the defendant wanted to kidnap a Publix manager's wife. He had decided that. He went to Publix. He found the picture. He had actually driven by the manager's home. But this court found that was insufficient of attempting to kidnap because he still had what the court called the sizable to-do list. He still had to gather the materials. Our position is Mr. Cano is in the exact same position. Thank you.
Thank you.
Thank you. Thank you all.
We have one case remaining on our docket, and you're going to have to be a little bit patient.